The case set for video conference this morning is Colleen Eltibi versus Kristin Kocsis. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and wish to reserve any time for rebuttal, please let me know when you get started. These arguments are being posted, are streaming live and being posted on YouTube. Please do not use the name of victims or children. I don't think that's relevant to this case, but we like to remind all parties that this will be on YouTube. Okay. We have read the briefs and we are ready to proceed when you are.
Thank you, Your Honor. I have an interruption coming in. Hold on, please. I apologize for that. Your Honors, my name is Jeff Holland, 0040089, attorney on behalf of the appellant. I would like to reserve 5 minutes for rebuttal, if you please. Your Honors, this case is a replevin case. It's a replevin over a piece of personal property. Interestingly enough, it has to do with a dog, but dogs are personal property, just like a car or a sewing machine or anything else. Obviously the litigants in this case don't see it just as an animal, but as a valued item of property, more valued than normal property, and both consider the animal to be a member of the family. The way they look at the animal, though, doesn't change the way that we analyze how this case is handled. And Your Honors, the appellant filed a motion, or rather an action for replevin to have return of her dog, whose name is Albus. Now, Albus was purchased in August of 2015. She was purchased under a contract, which was with the Madison County Humane Society. The Madison County Humane Society contract specifically says that she is prohibited from transferring the animal to anybody else. Other than the adopter, or the word adopter is used in animal transactions, but it's actually a purchaser, and she's the only purchaser on that contract. She then takes the animal immediately and registers the animal. She takes the animal immediately and gets veterinary care for the animal and pays for that veterinary care. So the point, I guess, from the primary point here is that all of the evidence indicates that at this point that the sole owner of that animal is the appellant. And what we know is that in Ohio that we do have a statute that talks about how animals are transferred and what kind of a document you need to effect the transfer of ownership from one person to another. And that is Revised Code Section 955.03, which says that you shall give a buyer a transfer of ownership. It shall be signed by the seller. There's a registration number of the dog, the name of the seller, and a brief description of the dog. And this adoption contract has all those things. So there are two issues here, two legal issues, as to whether or not the appellant met their burden of production and whether or not they met their burden of persuasion. And a slightly different analysis, and I'm sure this court is familiar with it. The question on burden of production is whether or not there was a sufficient facts for the court to come up with the conclusion that it came up with. In this case, remember that the appellant asserted sole ownership of the dog, and the court's decision was not merely that she failed to prove by a preponderance of the evidence that she was the sole owner of the dog. The court's decision in this case was that the dog was co-owned between the two and that neither owned more than 50%. That's precisely what is said in both the magistrate's decision and in the court's ruling at the very end. So there needs to be some sort of evidence to show that there's a co-ownership in order to uphold the court's ruling, the trial court's ruling in this case. And our position is that since there is no transfer of ownership showing a transfer of any amount of the ownership pursuant to 955.03 to the appellee, that by matter of law that meets the fails to meet the sufficiency of the evidence for this case. Furthermore, we believe that the trial court did not make the correct ruling on manifest weight of the evidence. So the question is whether or not the burden of persuasion was met. And again, I'm very well aware that the court has to take all of the factual findings, factual findings of the magistrate and the judge as they found them. The people that were found to be credible at the trial court level is up to the trial court judge. But the only evidence that there is indicating or arguing in any way that the appellee is an owner is that she makes a statement that when the animals were first purchased, she felt as if that they were purchasing the animal together. She wasn't on the adoption contract. She didn't say that there was an agreement between the two of them, but she felt that that was the case. And her unilateral feelings is not sufficient to sustain the finding that was made in this case. So if the sole owner was the appellant, then our position is that that what you would have to show is you would have to show that that there was a gift that was being made. And if there was a gift being made, that's a clear and convincing evidence argument. Now, appellee's brief says there was no gift, that this was so that's not really even an issue. Appellee concedes that there was no gift. Their sole argument is that appellee was a co-owner from the get-go. What's the evidence of that? All we have is that years later, she paid for a number of different things for the care of the animal during the time that they lived together, and that she filed a registration document. But remember that a dog registration is not proof of title, and we agree on that too. Appellee and appellant agree on that issue. It is not the title because a registration fee is a tax, and it is required for every person who owns, keeps, or harbors a dog. So you don't have to be the owner to pay the registration fee. So that's not really proof of ownership. It's just one suggestive thing that something was done for this animal, and testimony was that appellant asked for that to be done because she had another conflict. Given the fact that there is no transfer of any kind of the ownership, all we know is that the appellant was the original owner of the animal, and that there is no independent factual basis for an alternate conclusion. I think that concludes 10 minutes, and I would reserve the remaining 5.
Counsel, can you share with me a little bit more about there was some sort of back and forth sharing of the dog. Was there an agreement to that effect?
Yes, Your Honor. I think that what the testimony shows is that they agreed that that she would allow her former roommate to share the dog, and she would drop the dog off as a courtesy and let her, because the appellant recognized the appellee was bonded to the animal. So they had an agreement to drop off the animal once in a while, and eventually in May 4th of 2020 was the last day when appellant said, well, I'd like to have my dog back, and she said no. And that's what prompted the filing of the replevin action.
And on that day that she did not return the dog, was there an expectation or agreement that she would return the dog that day?
Yes.
Thank you.
Thank you, counsel. Counsel for the appellee.
Thank you, Your Honors. First of all, thank you for your time today and allowing us to appear by Zoom. On behalf of Kristin Kocsis, Ron Starkey for the appellee, And first of all, for the court, I would suggest that what we are here today about is a replevin action. And the court needs not be reminded of that, except for the fact that in a replevin action, a party must be able to satisfy to the court that they are the sole owner of the property seeking to be returned. We all agree, though I'm a pet owner myself, that dogs are chattel under the laws of the state of Ohio. However, this was a replevin action. Ms. Kocsis also contended that she was an owner of the dog. The lower courts, beginning with the magistrate, found after hearing testimony and documentary evidence presented at the proceeding that neither party had satisfied the burden of proof to establish to the satisfaction of the court that the property was solely and only the possession rights of one of the parties. Based upon that finding, the court concluded on both claims and the cross claims that neither party was the sole owner of the property. What is significant, I think, to the court of a primary matter is the fact that under first and foremost, at the trial level, at the magistrate trial level, neither party requested detailed findings of fact and conclusions of law. And then after the period of time had expired for a party to request detailed findings of fact and conclusions of law, a party submitted that request, but it was untimely under the civil rules, specifically Civil Rule 53, and the court denied that request. Having that record before this court, the court is only allowed to consider whether or not the plain error doctrine applies to this matter in reversing the decision of the lower court. We submit that under the plain error doctrine, which of course is not generally recommended or recognized for civil matters, that there is no establishment that the procedure that the Supreme Court has established for doing a magistrate heard matter then reviewed by the trial court is appropriate to set aside this matter. The magistrate had the ability to take the evidence, hear what the parties had to say, and evaluate their credibility. Under that standard, and the failure of a party to request detailed findings of fact and conclusions of law, the magistrate's decision and then that decision of the trial court should sustain. In addition, as we briefed to the court, we are somewhat perplexed by counsel's agreement that on one hand, the state of Ohio, unlike automobile titles, dogs are not certificate of title ownership in the state of Ohio. So we both agree on that, but then on the other hand, counsel attempts to use that as an indicia that the ownership should only be that of Miss Eltibi. As the court has probably gleaned from the facts of this matter, these two individuals were in a romantic relationship. My client was also involved in the purchasing and the reviewing and the acquisition of this pet. In fact, my client, as the record demonstrates, was a big Harry Potter fan, and the dog is named Albus as one of the characters from Harry Potter. The parties, I believe, the testimony established at the lower court level that the parties each had badges of ownership significant to the trial court that neither party could establish that they were the exclusive owner of this property. That being the case, the replevin action was not an appropriate action, and the court was without any other remedy to rule otherwise based upon what was presented specifically to the trial court at that level. Despite what counsel says, a review of the record will show that Ms. Kocsis attended and participated in the adoption down in Madison County, that she also participated in his formal training with dog trainers. Testimony did establish that she paid in excess of $2,500 toward the care of Albus during the time that the parties were together. Again, this was not someone who was asked to borrow someone's dog on occasion and dog sit for them. These two people who were in a romantic relationship had joint ownership of a dog, and that's what was found and decided by the lower court. Again, we think the plain error doctrine does not apply here, and that the arguments now waived are presented by new counsel subsequent to the trial are not appropriate before this court. Beyond that, we also believe that the manifest weight of the evidence supports the decision of the lower courts that the property was jointly owned and neither party could sustain its burden of proof to establish replevin.
Mr. Starkey, why do you, if the position of your client is that that they were joint owners, why do you believe that she is entitled to possess the dog?
Your Honor, I would say at this point in time, her possession of the dog is limited only to the standpoint that the action, the relief sought by both parties was only replevin. So the trial court was limited in its ability to do what it could do. The only other option at this point in time, which neither party has filed process at the moment to do, would be for a partition action, because that's what we do in the state. When we have jointly owned property, we have to file a partition action. That would be the remedy to pursue, but that remedy has not been sought by either party at the moment.
Counsel, revised code section 955.11b defines the transfer ownership of a dog, does it not?
It does, Your Honor.
And so, and that is that is something that occurred between the Humane Society and the appellant, is that correct?
I would, Your Honor, except for the fact that also that section of the code recognizes under revised code 955.03 that dogs are still chattel in the state of Ohio and the common law provisions still govern. So that's different than like revised code 4511 governing motor vehicles. It's more of a registration issue, and the only penalty for that is a minor misdemeanor citation that someone could be issued for failure to register dogs.
And counsel, so it was not the position of, I just am trying to clarify, can you just clarify for me, the position of Ms. Kocsis was that that they were joint owners of the dog, not that she was the sole or exclusive owner of the dog?
Your Honor, initially in the pleading process, both parties took the position that they were the exclusive owners of the dog. And as the proceeding advanced at the hearing level, we conceded that we were joint owners of the dog, and we've not pursued anything further than that because we believe that the magistrate was correct in concluding that neither party established badges of ownership exclusive to the other.
Thank you. One last question, I'm sorry, counsel.
Yes.
On the day that Ms. Kocsis decided not to return the dog, what can you explain to me the agreement that they had on sharing the dog?
Yes, ma'am. Previously, the parties had a shared dog relationship, a shared dog parenting agreement, if you will. Even though they were no longer romantically involved with one another, they would exchange the dog back and forth. Ms. Kocsis was living in Stowe. I believe Ms. Eltibi was living in the Cleveland Lakewood area, and they would exchange the dog back and forth. It reached a point where, and it's in the record, reached a point where Ms. Kocsis was concerned that the behavior of the dog when he would return from time with Ms. Eltibi was different, and she was concerned because she had previously observed Ms. Eltibi discipline the dog in a way that she did not feel was appropriate. So she was concerned for the dog's safety, so she declined to further exchange the dog. Again, but as the court knows, the best interest of the dog is not the issue before this court.
Thank you.
Thank you.
Thank you.
Counsel. Mr. Holland, you have 5 minutes remaining for rebuttal.
Thank you very kindly. I guess first I'd like to address the issue of whether or not there's a findings of fact issue that that precludes this court from proceeding, which is appellee's position. I think that is incorrect. First of all, the order that comes from the court when a request is made, the initial order that was made by the magistrate did include findings of fact and rulings of law. The additional motion was to elicit more findings, more specific findings, in fact, and rulings of law. That request was denied. And what the order says is it says the magistrates, it says request for findings of fact and rulings of law must be made within 7 days. Therefore, the plaintiff's request is untimely. Further, the magistrate's decision provides adequate findings and, combined with the transcript, allow for plaintiff to sufficiently object. So the trial court did allow the objection to the magistrate's ruling, and that's what happened. And it is appropriate for this court to then review that. What I would say is that romantic relationships is not a divorce, and Ohio law has noted that for a long time. Just because you purchase something while you're in a romantic relationship does not give you right to that property. When she says that when appellee says that she was participated in the purchase of the animal, she was physically with her roommate and her maybe her lover, but she was with this individual when the purchase was made. Her name is not on the purchase agreement. She suggested a name and they called it that name because she's a Harry Potter fan. If that makes you the owner of property, the co-owner of property, or the fact that you might pay for something and that makes you the co-owner of property, how many times have you lived with a roommate and you've shared a car? And then the other person says, look, I'll get the oil changed. You let me drive to California. You know, I'll get the engine repaired. You let me drive to California with your car. That doesn't make you the owner. There is no law that says that. And during the trial, Ms. Kocsis never said we're co-owners. She consistently said throughout the trial that she's the sole owner, and the appellant consistently said she's the sole owner. The trial court lost its way by specific, and it's indicated by the specific finding, not just that the plaintiff failed to meet her burden of proof or a burden of persuasion, but that they are the legal finding that they are co-owners. It is not supported by the evidence. So that's our position. As far as not being certificate of title, yes, a registration is not a certificate of title. That is correct. And there is no certificate of title. That is an also correct statement of law. But there is a very specific statutory means for transferring ownership. And if you want to effectuate the transfer, you've got to sign that document. You've got to have that statutory document. And we know, counsel says, yes, animals are personality, and so therefore, and they're chattels, and therefore they're subject to the common law and so forth. I agree with that. But we all know that a specific statutory inaction overrides any general statute. And the specific statute says when you have a dog, not a cat, not a cow, not any other kind of animal, the way you transfer ownership is to specifically have a transfer of ownership document. That is not done in this case. She's not on the original purchase agreement. There is nothing that in any way that supports her becoming an owner. Only somebody who voluntarily helped to pay for a piece of property, considered to be a family member by both of them, that she loved while she was there and had personal attachment to. And why not? That's all I have. Thank you.
Thank you both for your presentations. Judge Sutton?
Thank you. I just want to bring to your attention that the 9th District does have a mediation program. I'm not sure if you have considered that possibility. Our program, the mediator works to try to come up with mutually acceptable resolutions, obviously, if the parties are so inclined. So I just want to bring that to your attention that we do have that.
We've taken advantage of that, Your Honor. Thank you.
Thank you.
Thank you both again for your presentations and for being available to the court via Zoom. The court will take the matter under advisement. We will issue a decision which will be mailed to both parties as well as posted on the Ohio Supreme Court website. We are adjourned for